Okay, good morning, everybody. This is the House of Representatives. We are the Committee on Corrections, Military, and Veterans. My name is Mark Hashem. I'm the chair. To my left is Corey Chan, Representative Corey Chan, the vice chair. Today is Wednesday, February 8th, 2023. It's 9 a.m. And we're in conference room 430 at the State Capitol at 415 Bishop Baratania Street. We're going to jump right in. First up, we have HB 262 relating to education. And first on my testifier list is Department of Education. In person, present? No? Are they on Zoom? No? They're with comments. And second, we have U.S. Department of Defense on Zoom. Yes?
Hi, yes, Kelly Mae Douglas here. Can you see me?
Yes, go ahead, Kelly, you got the floor.
Good morning, Mr. Chair, Vice Chair Chun, and members of the committee. My name is Kelly Mae Douglas, and I work in the U.S. Department of Defense, Defense State Liaison Office. And we work on quality of life, state policy with lawmakers to improve quality of life for military families around the nation. Thank you for allowing me to provide a few comments in support of HB 262, a measure to ease enrollment challenges for military families with school-age children. Military families move frequently and change school systems upwards of 10 to 12 times prior to graduation. In addition to planned permanent changes of station moves from state to state, military families often also move subsequent to the move into the state from temporary to permanent housing. One of the biggest challenges for military families is that they often are assigned to a location on military orders in the spring, but they don't arrive until the late summer or early fall. And they often are not provided opportunities to enroll in school at the same time as their peers that are on island. We're asking that they be allowed to enroll ahead of time, temporarily until they arrive, and then provide proof of residence once they arrive. So just want to thank you for considering this measure. It's very important to military families and the Department of Defense. Currently, 35 other states have passed this initiative in the last 5 years, and we'd be ecstatic if Hawaii was the next state to consider this very, very beneficial policy. And I stand by to answer any questions you might have. Thank you so much. Mahalo.
Okay, thank you very much. Next up, we have Chamber of Commerce in support. And then we have an individual, Kristen Prentice, in support. That's all the members, that's all the people that we have, that's all the testimony that we have in front of us. Members, are there any questions? Seeing none, we are moving on. Next up, we have HB 1129 relating to incarcerated women. First up, we have Department of Public Safety Director Tommy Johnson in person.
Thank you, Chair Hashem, Vice Chair Chun, and members of the committee. I'm Tommy Johnson, the Director of the Department of Public Safety. I'm going to essentially just summarize our testimony. We support this measure. However, to ensure the integrity of the GED tutoring and test-taking process by documented GED records using the Essential Education's website provided by the DOE in our correctional facility, PST recommends the appropriation for funding be expended by the DOE, MSCA, and Mauna Lua that issues our diplomas.
Okay.
We have our educational administrator here and corrections program division chief to answer any technical questions you may have.
All right, thank you very much.
Thank
Next
you.
up, we have University of Hawaii with comments.
Good morning, Chair, Vice Chair, and members of the committee. I'm Della Teraoka, Interim Associate Vice President for Academic Affairs at the UH Community Colleges. We stand on our testimony and support, and we're available for questions.
Okay, thank you very much. Next up, we have Community Alliance on Prisons, Kat Brady, in support.
Good morning, Chair Hashem, Vice Chair Chun, and members. Kat Brady testifying on behalf of Community Alliance on Prisons. This is such an awesome program. This has trained peer tutors to actually train the women who are incarcerated to help other women get their GEDs. Before this program, there were only 2 or 3 people who actually passed. Now they had 20 in the last 6 months. So it's a really terrific program, and we know that education is the economic mobility that moves people forward. And most of the women are moms. So this is really, really important. Thank you so much.
Okay, thank you very much. Next up, we have Hawaii Friends of Restorative Justice in support.
Good morning. Thank you. And yeah, we support this, but and we do really think it's very important that the funds go to Windward Community College, because Windward Community College is a partner in this project, while the community school, the McKinley, is not. They were originally helped with the certification of the tutors, just they signed the certificates that we did all the training, and Windward is the one that's doing the Windward Community College. And the certificate for the tutors to pass the tutor training, it's a lot more viable with a community college certificate than it is from a community college. I mean, a community school. You know what I'm saying? Like a high school compared, secondary compared to that. But yeah, if you have any questions, it's been a fabulously successful program. Just, it's remarkable. And the women too, it's so great. The tutors they're all going to college when they get out of prison.
Okay, thank you very much. Next up, we have Attorney General comments.
Good morning, Chair Hashem, Vice Chair Chan, members of the committee, Deputy Attorney General Candace Park. Just want to point out 2 things. If this is intended to be a grant to Hawaii Friends of Restorative Justice, we've provided language that needs to be included in the appropriation language. Second thing, if it is the intent to have the Windward Community College administer grants, then the statute would need to be amended to include standards for providing such grants. And I'm available for questions. Thank you.
Thank you very much. Next up, we have Women's Prisons Project in support via Zoom.
Yes. Aloha. I'm Linda Rich, and I'm testifying on behalf of Women's Prison Project. We strongly support House Bill 1129. Look, you have my written testimony, and I just want to emphasize a couple of things in that testimony. First of all, this is exactly the kind of rehabilitative program that should be happening in our institutions, our correctional institutions. It's working. You've already heard about the dramatic increase in the number of women who are participating in education as a result of this program. Recidivism is reduced as people who are incarcerated participate in education. That's a research-based fact. That's not just something that we're saying. This program is having an incredible impact. Actually, I would like to point out that there were some issues last year when an appropriation was made for this program to the Department of Education rather than to the community college. In fact, that money has not yet reached the program that was appropriated last year. So Women's Prison Project would really like to urge you to pass this bill and to fund this program, which is having a dramatic impact on the women in the Women's Correctional Facility, and to appropriate that money to Windward Community College. Thank you, and I'll be available for any questions.
Okay, thank you very much. That is all the people that we have registered to testify today. We have written testimony in support and comments from about a dozen other individuals. Is there anybody else wishing to testify? Seeing none, members, are there any questions? Seeing none, yes, I have a question. Tommy Johnson probably, and you'd probably be the best person. So, the public safety apparently already does this, or is it just McKinley High School that does this?
Let me bring up the administrator for the education program. They'll know the details.
Okay.
So it's McKinley Community School for Adults, the Moanalua campus that we partner with, and they issue the diplomas once the students have completed the process of testing, which includes many steps as far as tape testing, the GED Academy program, which is essential education, a web-based program that we use, and then practice tests and GED testing. So once they go through that process, which we work with McKinley to have part-time teachers and instruction for the students before getting their tests.
Yeah, how many students do you run through already through McKinley? Do you know?
So currently in the GED program, there are about between 19 and 20 students who've been preparing and testing at Women's.
How is it different from this nonprofit running this program? Because, okay, let me tell you, I talked to the principal at McKinley High School, and she said they already have this program going and it's federally funded.
Yeah, so again, it's
so
it's
why?
McKinley
I mean,
Community
so
School.
we're having two systems, right? Why are we having two systems? One
So-
federally funded system, and where now they're coming, the nonprofit is coming and asking for the same,
And
a
the
similar
reason
system,
the
right?
nonprofit is because they had a grant that funded this program. They initiated this program, which has been successful and for the students, which is that they are providing a monetary incentive for the women, which we don't do. The partnership that is federally funded that we have with McKinley Community School for Adults, Moanalua campus, funds all of the testing and the programs that we have, to help provide the women instruction. But we have never offered a monetary incentive for the women to prepare for their GED, or when they become tutors, now they become, paid to be a tutor. All of that was a part of a different grant that was initiated, I think, 2 years ago.
Okay.
That's the difference.
So
And that
why-
has helped to motivate more students to participate. And I think part of the reason why it has been highly successful.
All right. Yeah. Okay, let me think about this. Because it seems like we have two programs doing the same thing, right? Don't you have, isn't this program?
So this is the peer tutoring program, which is different from what we do with McKinley.
Okay. No more questions. Members, any other questions? Seeing none, we're moving on.
Can I just say something? Because we developed this program in partnership.
Yeah, okay, yeah, come up.
We developed the program in partnership with the women's prison. The state does have, they do have a GED testing program, and they do have, they were able to graduate a couple people a year with a GED, and that's what McKinley does. They test the people. What we did was develop, and it's not just monetary incentives, and it's not just continuing education, getting your GED. This is a whole package of reentry. We use a methodology, it's called cooperative learning, and it's where you get to participate. So that's why we use tutors. That's part of cooperative learning, is where you are a source of information. And so you get to participate. It's kind of like Montessori school, where you get to be in there doing things. And that is really what's helped the women. The problem with the state wanting, the Department of Public Safety wanting the money to go to McKinley, we don't understand why they want it. Who you talk to, Helen, I put in our testimony, she wrote us an email. She wrote an email to Artis, who is the chancellor at Windward, a couple of weeks ago, and it said she didn't even want to do this. She doesn't want to do this. She said that in her email. She hoped that Windward was going to do it, And they've got the money last year. The legislature did give us funding for this project, but we've not seen a penny of it, except I think we're hopefully going to get. So another part of the money goes to fund a counselor who works for Windward to help the women in prison navigate how to go to college when they get out. That's what the bulk of it is. It's over $100,000 for that position. We also buy correspondence classes for women, because there's some women in prison, they can't take any college classes in there. So we contract with a college in Colorado, Adams State University, and they, a woman, we're able, we've got some women who have got life terms, but they can still, and we've shown, there's research that show if women get educated, people get educated, there's less violence. That people get along in prison better. So it's good to educate people. So it reduces bad thing.
Okay.
So it's totally different. It's a completely different, this is not just a GED, it's not a GED program. We don't have anything to do with testing for GED. We just have we provide these tutors that teach the other women, their peers, how to study for the GED and pass the test. That's why it's been successful, that piece. But it has a lot of other elements to this. It's not just that. There's also reentry planning. You know, we do restorative circles for reentry planning to help you. How are you going to further your education if you're going to stay in prison or if you're going to get out? What are you going to do? So it's not so simple. Sorry.
How is that different from the reentry planning that we already have at Dole Cannery?
At Dole Cannery?
Right? Isn't there a program that we haven't? You know what? That's
Oh,
okay.
I know what you're
We're
talking about.
moving-
Epic
okay.
Ohana Conferencing. That's child welfare.
Okay,
Yeah,
we'll move
yeah.
on.
Okay,
That's
thank you.
Thank
Thanks
you.
a lot.
Next up, any questions? Seeing none. Next up, moving on to HB 1130, relating to corrections. First up, we have Department of Public Safety, Tommy Johnson. Okay, next we have Hawaii, the Commission. Martha.
Makes it easier.
In support.
We support this measure because we think trauma-informed care is very important for the healing of people who are committed to the Department of Public Safety. Training staff on trauma-informed care is not a new concept to the Department of Public Safety. In 2010, former Warden Mark Patterson established a trauma-informed care initiative using federal funds, which began with training of WCCC staff and community and state agency partners who worked with incarcerated women. The elements of that training were incorporated into the basic correctional training curriculum at the department's training academy. We are under the impression that the emphasis on trauma-informed care training has fallen by the wayside over the years, and this measure will reestablish it. One of the things that has fallen by the wayside, no longer does a subject matter expert provide this training.
Okay, thank you very much. Next up, we have University of Hawaii with comments.
Hi, we stand on our testimony and support.
Okay, thank you very much. Next up, we have UPW with comments.
Good morning, Chair Hashem, Vice Chair Chun, members of the committee. Kamakana Kaimaloa, Government Affairs Manager, testifying on behalf of State Director Kalani Werner. You have our written testimony. I'd like to clarify that we actually strongly support the intent of this measure. But we would like to note that due to current staffing shortages as well as mandatory overtime, it may be difficult for ACOs to actually access this program, and they would likely be unable to regularly attend courses proposed in the bill without supporting consideration from the Department of Public Safety. Thank you for the opportunity to testify.
Okay, thank you very much. Next up, we have Hawaii Friends for Restorative Justice. In support?
Yes, we support. I'll stand by.
Okay, thank you. Next up, we have Judiciary State of Hawaii with comments. Oh, nobody is. Okay, so that's all the registered people. That's all the people we have registered to testify. We have probably about a dozen more in support. Is there anybody else wishing to testify? Is there anybody else on Zoom?
Yes, I actually did submit testimony to be presented on video.
Good. Please state your name and go
Yeah,
ahead.
I'm Linda Rich from the Women's Prison Project. We're strongly supporting this measure. Basically, trauma-informed care is standard practice with most vulnerable populations, which the prison population is. And one of the reasons it's so important is that we have such a high incidence of trauma among women and men who are incarcerated. And what happens with trauma-informed care is that people working with the persons who are incarcerated have an understanding of what triggers a trauma reaction, which is basically a fight or flight reaction. So trauma-informed care makes the staff safer and makes the people in the facility safer. It reduces aggression. That's another research-based fact, that when you have a trauma-informed care system, it reduces resistance and it reduces aggression. So we urge you to pass this measure. Mahalo.
Okay, thank you very much. Anybody else wishing to testify? Please come up.
Aloha mai kako, Chair Hashem, Vice Chair Chun, and Representative Poi Poi. I'm Artis Eschenberg. I'm Chancellor at Windward Community College. And I just wanted to let UPW know and the committee know that we will be offering the courses as an alternative, asynchronous and online, so that you're able to do, because we recognize also that many of our COs have shifting schedules where their times change, and that way they're able to do it outside of business hours.
Okay, thank you. Good. Anybody else wishing to testify? Seeing none, members, are there any questions? I actually have a question for Martha, the commission. You mentioned that there was a history of this before. Was it done at Windward Community College, or was it done in the facilities?
It was done in-house, so it was supported by, I believe it was National Institute of Corrections grant, and it was Mark Patterson, the warden, who coordinated it. And then again, the curriculum was developed for
Someone
our
else from
basic
the
program.
outside came in and
Yes.
taught it within the facility.
That's
So
what
that
the
makes
money
it a
was
lot
for.
easier for UPW for your employees, right? Okay. Tommy, now I'm talking across the room, sorry. Director, are you okay with having this program put in-house so that the employees don't actually have to go anywhere?
I don't, but as UPW pointed out, our staffing levels are so low now that it would be hard for us to pull somebody off a post to go to the training. And so if we're required to do it, then it's a negotiable item, because if we do it during duty hours, and we have to make sure that we compensate the staff for it. So I have no objection to the trauma-informed care. I do think it's good to have it on video and in person. It would be best to have an outside entity come in to do it at different times and on different dates. We have 3 shifts, from 6 in the morning to 2 in the afternoon, 2 to 10, and 10 to 7. So if we could work out with a vendor to come in and do it during those shifts as part of the person's normal rotation, that would be cheaper to the state.
Okay. So I'm thinking that if we give the funds directly to you, and what was it, only $100,000 I think they're asking for.
I don't think that's gonna cover it.
Yes.
We got 1,500 plus corrections officers statewide.
Yeah, so you could actually, I think everybody should have this, not just Windward Community College. So you could, what I'm trying to say, if we make it, if I direct the funds to you, you could spread it across the state, correct?
We would look for one vendor that could do it across the state. That would be the most economically feasible.
Okay.
person.
All right. Thank you very much.
Thank you.
Members, any other questions? Seeing none, we are moving on. Next up, we have HB 1131, relating to gender parity in programming for incarcerated women. First up, I need to get situated here. Department of Public Safety. Tommy Johnson, you should have just stayed up there. Okay, next we have Attorney General with comments.
Good morning again. Just wanted to point out that the bill requires the University of Hawaii to conduct a study, and in order to avoid any constitutional issues, we suggest that the bill be amended to insert that the law is a matter of statewide concern. Thank you.
Okay. Thank you very much. Next up, we have Stonewall Caucus Democratic Party in support. Via Zoom? No? Anybody else in Zoom? Okay. Women's Prison Project in support on Zoom. Linda Rich?
Yes. Aloha again. We strongly support this bill. There is a statute that requires parity for women in the programming in the prison system. We believe that this measure can substantially assist the entire correction system, because in order to assess parity for women, it's going to be necessary to look at programming across the correction system. And as the recent name change that will take effect soon for the department to the Department of Corrections and Rehabilitation, the importance of planning programs across the system that support rehabilitation is going to be very important. And this program, besides demonstrating whether or not there is parity for women, is going to show where the gaps are in programming across the correction systems, and will make recommendations for how the rehabilitative processes within the system can be strengthened. So we urge you to support and pass this measure. Thank you.
Okay, thank you very much. Next up, we have, that's all the members that we have. That's all the people that we have registered to testify. Is there anybody else wishing to testify? Seeing none, members, are there any questions? Seeing none, we are moving on. Next up, we have HB 1132, relating to the Hawaii Correctional System Oversight Commission. First, we have Department of Public Safety and support.
Thank you, Chair, Vice Chair, members of the committee. I'm Tommy Johnson, the Director of Public Safety. I'll just summarize our testimony. We support this measure. However, we recommend that Section 1 be amended to have the coordinator appointed for 4 years instead of 6. 6 years is the ombudsman's term. The missions are completely different, and it would be more in line with other boards and commissions statewide. We also recommend that the coordinator be required to be confirmed by the Senate. Given the level of responsibility for the position, we believe that the person should go through Senate confirmation. Thank you.
Okay, thank you very much. Next up, we have Hawaii Paroling Authority in support.
Frank Young, Hawaii Paroling Authority. We'll stand on our written testimony and support.
Okay, thank you. Next up, we have Hawaii Correctional System. We have the commission, Martha, in support.
I call it CSOC. Those are the
CSOC.
initials. Just I dropped the H for Hawaii. Okay, the Commission strongly supports this measure as it addresses 3 areas to improve the work of the Commission. The first is to extend the term of the Oversight Coordinator. It also is to allow the Commission to hold meetings closed to the public to follow up on investigations. And then third, allows the Coordinator unfettered access to all facilities. Senate Bill 455, the companion to this bill, was heard on Wednesday, February 1st in the Senate Committee on Public Safety. And testimony submitted by the Office of Information Practices and Civil Beat Law Center objected to Section 2 concerning the confidentiality of certain meetings as too broad. These sections concerned meetings closed to the public. We consulted with both these organizations and arrived at revisions that satisfies our needs and their concerns. Our testimony addresses these changes, and because the revisions are extensive, I have provided you with a draft replacement bill for this. And I can provide your committee clerk with an email from OIP Director Park that confirms that she agrees with the amendments.
Okay, thank you very much. Next up, we have Kat Brady in support.
Strong support. We are so delighted to have a professional that actually is steeped in oversight. She's done oversight in many, many facilities, and we think it's really, really important that we have this. So we're really excited about her term. You know, there is one commission that actually does have 6-year terms, and that's the Public Utilities Commission. And that commission has a mandate to transition Hawaii from fossil fuel into renewable clean energy. And that is a humongous task. So you actually need that kind of time for the research and for everybody to understand how this can actually happen. So we totally support the 6-year term for the coordinator because we're transitioning from a punitive system into a system that really focuses on rehabilitation and therapy. So we think that is really, really important. About Section 2 of the bill, I noticed that also. And one of the things that kind of didn't sit well with me was that after an investigation happens, you know, they'll let the legislature and the governor know. But this, what we would like to see is after an investigation is complete, that a report be issued by the commission and put on the public website that actually talks about how important it is to, I lost my train of thought, I'm sorry. But we think it's really important that an investigation report comes out at the next meeting where they actually talk about what happened, they redact all the names of people who spoke to protect the witnesses who came forward. But we think it's really important in transparency that this happens. This is a publicly funded agency, and the public really needs to know what's going on. So we hope that you adopt the amendments by the commission. And I also included an article from the oversight queen in the United States, Michelle Deitch. And she wrote a great article about the importance of oversight to have healthy, safe prisons. So thank you so much for this opportunity.
Thank you very much. Okay, next up we have Hawaii Friends of Restorative Justice. In support? Thank you. That is all the people that we have registered to testify. We have about a half a dozen other people with comments. One person opposed, but I think they're opposing that section 2. Is there anybody else wishing to testify? Seeing none, members, are there any questions? Seeing none, we are going to move on. Next up, we have HB 823 relating to deaths within the correctional system. First, we have the commission, Martha. In support.
The Commission strongly supports this measure, and the issue has been subject to litigation and brought before the Hawaii State Legislature in previous years. We ask that this year you resolve it. Thank you.
Okay. Next up, we have Tommy Johnson with comments.
Thank you, Chair, Vice Chair, members of the committee. I'm Tommy Johnson, the Director of Public Safety. I'll just real quick over the testimony. We provided comments, and we just asked for the recommended amendments to Section 1 on page 2 and 3 of this measure to clarify. Thank you.
Okay, thank you very much. Next up, we have Cap Brady in support.
Aloha. This is such an important bill. When something happens in the prisons or jails and somebody dies, there really should be a designated person from the department who actually contacts the family. I've gotten so many calls in the past where an ACO has left a message on somebody's machine saying, your daughter died. This is not pono. So we want to see a compassionate, rehabilitative system that actually understands the trauma that people go through while they're in the system and while their families are outside, the invisibly incarcerated. So it's really, really important that we straighten this out. I have talked with the director and asked, can you find out what other jurisdictions do? Is there a designated person? This is so crucial to receive that kind of information in sort of an offhanded way is not the way that we operate in Hawaii, and we shouldn't be supporting that. So I hope that we one day have one person who is actually designated to be maybe steeped in grievance counseling so that they can actually understand what the family is going through. So thank you so much.
Okay, thank you very much. Next up, we have Hawaii Health Harm Reduction Center. Nikos Leverens in support on Zoom. Nope. So that is all the members that is all the people that we have registered. Oh wait, yeah, that's all the members that we have registered to testify. Is there anybody else wishing to testify? Seeing none, members, are there any questions? Go ahead. Representative Ganadin.
Director Johnson. Good morning.
Good morning.
Does this align us with the recent ruling from the Hawaii Supreme Court?
The recommended changes we recommended, the recommended amendments we asked for, I believe it does. I did want to clarify a point, though. The wardens or above are the only persons that do notifications to family members of someone's death. It's not the corrections officers, it's the warden.
It's the warden.
It's the warden or above.
Okay. I think for me, this doesn't completely go to the root of what I think I'm concerned about. Like, what do people die of when they're in custody?
Well, the vast majority die of disease and natural causes. There are some assaults where that a person ends up dying from, but the vast majority are due to disease issues.
Will this bill mandate that the department keep statistics on inmate mortality?
We do a mortality review after every death in the facility, and we do have statistics on the number of inmates who die in the facility and in hospital or hospice.
Will those statistics lead to the state developing best practices around reducing inmate mortality?
Well, I think we already implement best practices. The mortality review does that. When we review, a mortality review is you look at and see what could you do better in the future moving forward with respect to processes and procedures. So the mortality reviews are fairly thorough.
I think what we're all trying to avoid is what happened in mid-2020 during COVID when there was discussion amongst guards, the union, within the public, and almost a public dispute between the then director and guards and like threatening litigation. So, I mean, do you think this bill will help us avoid that kind of a situation again?
I think it will help open up the information to get out there, but we do caution against some of the measures and some of the language in the bill. That's why we put forth 2 amendments, because a person still has a right to a degree of privacy, and so unless that person gives us written authorization to release certain information, then we're not allowed to release that information. There was a recent ruling by the court based on a lawsuit that the Civil Beat filed that requires us now to post information within 7 days after after the next of kin is notified. We don't have a problem with that. Myself and the previous director always wanted to release as much information as we could. We just caution against releasing too much information and people jumping to conclusions about information in the notification when we don't have the medical examiner's report yet.
Do you think that inmate overcrowding, I mean, we're all aware that all county facilities are overcrowded, leads to more assaults and inmate mortality?
I think it leads to frustration, and that frustration can lead to assaults. I don't necessarily know that we could link that to mortality, but our facilities are overcrowded, antiquated. We lack infrastructure that we need. Correct.
Thank you so much. Thanks,
Thank you.
Okay, thank you. Members, any other questions? I have one. Director, do you really need to put the person's name in there? Because it's within the statute, it says its name. Can I redact that?
You can. I don't have a problem with that.
Okay.
Because our position is, as long as the family is notified, the appropriate investigations are done, and if there's anything untoward happen, that appropriate justice is levied, I think it's fine.
So
But
if we just remove the person's name, do we really need written permission or anything like that?
I don't think we do, because we would only be releasing an age range and what we know at that time of death. But I can consult with the AG's office if you'd like.
Okay. All right. Thank you very much.
Thank you.
Members, any other questions? Seeing none, we're moving on. Next up, we have HB 432 relating to appeals. First up, we have Office of Public Defender in support.
Good morning, Chair, Vice Chair, members of the committee. My name is James Tava. I'm with the Office of the Public Defender. I am the State Public Defender. Our office supports this bill. I just want to note at the outset that there is an identical bill, HB 862, that was just heard by JJ yesterday. But so be it. Currently, if an inmate wishes to challenge the parole board's decision on their own, of their minimum setting, their only recourse is to file a petition for post-conviction relief. It's pursuant to Rule 40 of the Hawaii Rules of Penal Procedure. We call it a Rule 40 petition. It's basically filing a lawsuit. And I don't know how many people have tried to file a lawsuit on their own, but that's what it is. So the first problem is the inmate's not entitled to an attorney. They have to do it on their own. Number two, because the inmate has to fill out this petition or prepare this petition on their own, it's usually done by paper and pen, or pencil even. There is a form available if it is made available to the inmate, but even that form is somewhat complicated, asks a lot of questions, and it's more geared for trial court error rather than HPA error, so those are difficult. So basically, when they do file these petitions, well, many of them actually just don't review it because it's just too much trouble. That's what I heard. But when they do file them, most of them are denied, and they take a long time to get to the trial court because rather than the quick turnaround, because they're doing it on their own, if the court decides that there's not a legitimate or colorable claim, they only get appointed attorney. They don't even get a hearing. So what we ask is that just to make it fair and the inmates, just for review, it would be a more quick, efficient process if this bill passes. I am available for questions. Thank you very much.
Okay, thank you very much. Next, we have Hawaii Paroling Authority in opposition.
Morning, Chair Hashim, Vice Chair, committee members. The Hawaii Paroling Authority opposes HB 432, as we did yesterday with the companion bill 862, to allow for judicial reviews of orders fixing minimum imprisonment by the HPA. Passing this measure would, we believe, unnecessarily burden the sentencing courts to conduct a judicial review as well as present a potential conflict in the cases where the court has imposed a mandatory minimum for repeat offenders, which has been a lot of the cases recently. The Hawaii Administrative Rules also provides a criteria for minimum hearings and rehearings. The Hawaii Rules of Appellate Procedure, as the public defender indicated, allows for Rule 40 pro se filings as well as those filed by retained attorneys or, as we've seen, public defenders. Finally, HB 432 does not specify any process or standards for the courts. Yesterday's testimony by the judiciary, the attorney for the ICA, the Intermediate Court of Appeals, presented very compelling testimony as to the process. The HPA also receives letters from inmates, and we've received hundreds of those per year, which we act on, as well as forward to the Attorney General's office, and in some cases do rehearings. Otherwise, they'll go to the courts for decision, in which the Intermediate Court of Appeals may remand it back to the circuit court who did the sentencing, and after the sentencing matters have been taken by the circuit court, then the HPA may hold a rehearing on the minimum terms if advised by the courts. So I thank you for the opportunity to present testimony, and I'm available for questions.
Okay, thank you very much. Next up, we have the judiciary in opposition via Zoom.
Aloha, Chair Hashem and Vice Chair Chun and committee members. My name is Randy Pinal. I'm a supervising staff attorney at the Intermediate Court of Appeals. Thank you for allowing me to testify today. I apologize in advance on behalf of this committee because yesterday they heard me testify about HB 862 in the House Judiciary Committee, and my testimony on HB 432 will be similar, except I want to emphasize one significant difference and the judiciary's proposed alternative solution. So the judiciary opposes the bill because the existing Rule 40 process provides the best and most efficient way for an inmate to seek judicial review of their HPA minimum term order. It's not as daunting a process as the bill portrays or the public defender portrays, and the bill actually provides fewer protections for inmates. Those are all laid out in our written testimony, and in the interest of time, I'm not going to rehash them here. But one point that I want to emphasize that makes this bill different from HB 862 is that this bill would allow direct appeals to the ICA from any HPA order, whereas HB 862 would allow appeals from circuit court orders on motions challenging the minimum term only. So HB 862 is more narrowly tailored to address the issue that appears to be the focus of both bills. It's also important to note, I think, that in the last pre-pandemic fiscal year, HPA issued 6,762 merit decisions. And I don't know how many other non-merit orders, such as an order setting a hearing date or rescheduling a hearing date. Under this bill, HB 432, every single one of those orders could be appealed directly to the ICA, which would inundate the court with potentially thousands of new appeals each year. And one other thing I want to point out is that we included alternative language in our written testimony that we think is a workable solution that would satisfy all stakeholders. It seems the focus of this bill and HB 862 is the current lack of the right to counsel after the minimum term hearing. We oppose both bills as they're currently written, but we agree that perhaps it could be better for the inmates and the courts if the inmates were represented in those Rule 40 proceedings rather than the motion process that's contemplated by both of these bills. At yesterday's hearing on HB 862, the bill passed out of committee with recommendations that the introducer meet with the judiciary. We hope that happens and that we can make progress and reach a compromise with all interested parties. Mahalo for your time. I'm available to answer any questions.
Okay, thank you very much. That is all the people that we have registered to testify. Is there anybody else wishing to testify? Nobody else on Zoom? Seeing none, members, are there any questions? Representative candidate?
Mr. Tabe. Morning.
Good morning.
Thanks for coming back on this one. I was, as indicated by the gentleman from the judiciary, I was the introducer of HB 862, and I was basically voluntold by Chair Tarnas to bring the parties together to see if we can come to a compromise prior to that bill heading off to finance. But I did want to follow up on one thing. How many of the individuals that might be affected by this bill are repeat offenders for possession of a dangerous drug in the 3rd degree? The reason I'm asking is that these are the kinds of folks that we're trying to reach with our broader issues about pretrial justice and diversion programs. You know, these are folks who are possessing drugs because they're essentially addicted. You know, they're not violent criminals. They keep showing up and they keep violating because, you know, they're addicted to drugs.
Frankly, I don't have the statistics for how many of our repeat offenders and whatnot. It's just not available. We don't keep those statistics at our office. I do know that if there is a mandatory minimum, as Mr. Hewen has indicated, you can't go below the mandatory minimum. The HPA cannot go to.
When was that mandatory minimum set? I mean, what was that kind of a result of the war on drugs?
No, actually, the mandatory minimum on the, there was one on the crystal meth issue, but the mandatory minimum is usually based on the number of felony offenses that were committed prior to the current offense. So if a person has one current offense, the mandatory minimum is 1/3 of the maximum of the new offense. So on a 5-year sentence, it turns out to be about 18 months. On a 10-year, it's 3 years, 4 months, and a 20, it's 6 years, 8 months. So those are the mandatory minimums that are imposed by statute. Now, a court, when faced with rather than impose a mandatory minimum, if mitigating factors are present, a court has the authority to reduce the mandatory minimum from anywhere to time served. So it's not though the statute indicates it's mandatory, there is discretion given to the sentencing judge to reduce the mandatory minimum. And I guess that's maybe there is some frustration, to be candid with here, is that we do know that some judges will reduce the mandatory minimum, harsh mandatory minimums, to a number where it's, let's say it's a 5-year sentence or a 10-year sentence. It's 6-8 because of the priors, but the inmate has, there's just one true story here. There's one inmate went to Habilitat, completed the program pre-trial or pre-sentencing, because after you pled guilty, if the person is in the program is trying to do their best, And a judge who sees that will just delay sentencing months and months. And this Habilitat, it's a 2+ year program, so sentencing was delayed quite a long time. Got the graduated, completed, all better, or on the road to recovery, because obviously you never recover, but on the road to recovery. When faced with the parole board imposed an 8-year minimum, while the mandatory minimum, the judge issued basically 2 years or whatever was equivalent to his pre-sentence credit. In those situations, that person would, I don't know why he or she, why he didn't file a Rule 40 petition, but it's some cases like that where we'd like to present it back to the trial court saying it's just, from 2 years to 8 years, there's a significant difference. We like that reviewed.
So to clarify with that example, somebody went through the program, got clean, complied with every order of the court, and then was sentenced to a full 8-year term?
Well, it's a 10-year term with a mandatory minimum of 8 years, yes. I mean, not a mandatory, with the HPA minimum term of 8 years. So things like that, that's the most extreme, but it happens. Now, obviously, the parole board has the discretion. I would imagine the judge would rule on an abusive discretion standard. If it's like 1 year or 2 years, I think the judge would have to defer to the HPA. But something like this should have review right away, and the best court to review it is the sentencing court. Now, so I mean, those are examples, and usually I would imagine that when there's cases more technical, if we don't think that the board, which they usually do, and I think they do almost all the time, follow their guidelines, but if we disagree, we would like to challenge that. But as current state now, it's up to the inmate, and they do it on their own. And I would imagine many inmates, because it's a Rule 40 petition by paper and by paper, pen, and just the information just to gather everything, it's discouraging.
Do you think this bill is an intermediary step before addressing mandatory minimums that were created during the war on drugs? And the example that you gave, it's like, somebody's sent back to a facility after completing a full program at great expense to the state.
Well, that's fortunately the mandatory minimum statute. It's a separate statute, and it applies to all offenses, not just drugs. It applies, if you commit 2 drug felonies, and you pick up a robbery, which was let's say a Class B robbery, it's a mandatory 6-8. So it's the mandatory minimum statute covers all offenses. Well, frankly, it covers 95% of the offenses, because there's always a bill every year they'll add another to be included in the mandatory minimum. Somehow it just slips away, but let's say it covers the majority of offenses. So it's just not focused on drugs. I think there was one mandatory minimum on drug possession. Again, that was crystal meth. That was during the height of the crystal meth problem, but that, I believe, has been taken away. So there is specifically, there's no mandatory minimum on possession of drug offenses at this time that I know of.
Thank you.
Thank you. Members, any other questions? Seeing none, we will recess for decision making. Okay, thank you very much. We are reconvening our 9 a.m. hearing regarding corrections, military, and veterans. First up, this is decision-making for HB 262 relating to education. Chair's recommendation is to pass this with an HD1 and to put a defective date on to June 30, the year 3000. The intent is not to make it go into effect 1,000 years from now. The intent is for this bill to come back, so we can reassess it and work on it during the process, and it'll ensure it to go to conference. Is there any questions or concerns? Seeing none, Vice Chair for the vote.
Okay, members, we're voting on House Bill 262. Chair recommends we pass with amendments. Chair and Vice Chair will vote aye. Representative Ganadin?
Aye.
Representative Ichiyama?
Aye.
Representative Morikawa?
Aye.
Representative Poi Poi?
Aye.
Representative Takayama?
Aye.
And Representative Souza?
Aye.
Chair, your recommendation is adopted.
Okay, thank you very much, members. And I'm gonna make a blanket statement. All the bills are gonna be defectated to June 30, 3000, and that is to ensure that the bills come back for conference. So if I forget to say that, it's for the record. Okay, going on, HB 1129 relating to incarcerated women. We're gonna pass this out with an HD1. We're gonna insert the AG's amendments, and we're gonna zero out the funding, and that is it. Members, are there any questions or concerns? Seeing none, Vice Chair for the vote.
Okay, members, we're voting on House Bill 1129. Chair recommends to pass with amendments, noting the presence of all members. Do we have any members that wish to vote with reservations? Any members wishing to vote no? Seeing none, Chair, your recommendation is adopted.
Okay, thank you very much. Thank you, members. Next up, we have HB 1130 relating to corrections. The Chair's recommendation is to zero out the funds, make the funds go to public safety. And the reason why I'm doing this is because I would rather have this be a statewide program, so that way we can, I believe everybody in every prison should have this training. And hopefully the Finance Committee can put additional funding to see this happen. And that's the Chair's recommendation, and to defectate it. Are there any comments or concerns? Seeing none, Vice Chair for the vote.
Okay, members, we're voting on House Bill 1130. Chair recommends to pass with amendments, noting the presence of all members. Are there any members who wish to vote with reservations or no? Seeing none, Chair, your recommendation is adopted.
Okay, thank you very much, members. Next up, we have HB 1131 relating to gender parity. The Chair's recommendation is to take the public safety's amendments and zero out the funds, and that's it, and put a defect date. Are there any questions or concerns? Seeing none, Vice Chair for the vote.
Members are voting on House Bill 1131. Chair recommends pass with amendments, noting the presence of all members. Are there any members who wish to vote with reservations or no? Seeing none, Chair, your recommendation is adopted.
Okay, next up, we have HB 1132 relating to the commission, Hawaii Corrective Systems Oversight Commission. Yes, and it is our fault because we gave you this long name. The Chair's recommendation is to take the commission's draft as the HD1 and defect date it and push it out. They've been working with the stakeholders with OIP to get to work out the language on this, so we'll put that in as the HD1 and we'll push it to finance. Members, are there any questions or concerns? Yes.
Just a disclosure again for the record that Mark Patterson is the chair of the Oversight Commission, is my cousin. I know there was positive testimony on his behalf today, so just making that disclosure before we vote. Thanks.
Okay, thank you. No conflict.
Thank you.
Go ahead.
All right, members, voting on House Bill 1132. Chair recommends pass with amendments, noting the presence of all members. Are there any members who wish to vote no or with reservations? Seeing none, Chair, your recommendation is adopted.
Okay, thank you very much, members. Next up, we have HB 823. Chair's recommendation is to pass this with an HD1, and we're just going to defect the date to June 30, 3000. Are there any not recommendations? Are there any concerns? Go ahead.
Hoping that this bill doesn't mandate it, but maybe the Correctional Oversight Commission and the department might compile statistics for legislative review at some point.
Okay.
Regarding inmate mortality.
All right, thank you. Any other? Nope, seeing none. Vice Chair for the vote.
Okay, members, we're voting on House Bill 823. Chair recommends pass with amendments, noting the presence of all members. Are there any members who wish to vote with reservations or no? Seeing none, Chair, your recommendation is adopted.
Okay, thank you very much, members, for your support. Last up, we have HB 432. The Chair's recommendation is to use HB 862 as the vehicle that is moving on to finance. It's a similar bill to this, so we're gonna defer HB 432, and the vehicle for this issue will be HB 862. Thank you very much. We are adjourned.